Viewers, greetings. This is Soumitra Lahiri from guide to IBC.com. We could not upload any video in the last about 3 months' time because of multiple personal reasons as well as professional reasons. But having done that, from now onwards, you will get at least one video every week. It is impossible to compile selected judgments for last 3 months. Then the video would run for 3 hours. So this video which you are getting with this comprises of judgments which has taken place during the 3 weeks of November 2025. So with this, I take you over to the presentation.
The first case we are going to start with deals with section 3, subsection 4. Let's move on to the website. So what is 3 and subsection 4? You can see it is the deals with charges. Now let us move to the topic. The topic says if there is a first charge statutorily created validly, the horse non-obstantiate clause conferring priority over other debts, the statutory charge would prevail. This is a case which was recently decided by Honorable Supreme Court of India. You will find details of the case in the website. Now, in order to make things more precise and understandable, I have prepared a PowerPoint presentation. And let me take you to the slide share. The Supreme Court said initially what I told you, that if there is a first charge statutorily created, validly the horse non-obstantiate clause, and at the same time, what Supreme Court said that when there are two enactments conferring priority in satisfaction of a debt, the time in which such statute was enacted or the provision was incorporated assumes significance, and the provision introduced later would prevail. This pertains to cases like Insolvency Bankruptcy Code surfacing. Now, in this, Supreme Court has said that when a debt is secured by reason of provisions of a statute and becomes the first charge over properties under the meaning of Article 372 of Constitution of India, it prevails over crown debt. But there are other family of charges, like welfare charges, welfare enactments. There are municipal enactments, so which also create charge. Now, charge is a much larger thing than mortgage or charge itself or etc. It encompasses everything. So when a charge is mortgage, it gives absolute power. So when such a thing is there, like a provident fund claim. Now, under SARFAESI Act or under IBC, you can auction the property. But the liability which has accrued on account of provident fund, you have to pay that first and then use the proceeds for paying to the secured creditor. So with this, we move on to the next case. Thank you. Now, the next case which we are going to deal with pertains to section 3 only, but subsection 30. It is subsection 30 is what? Let us move to the website. You can see on your screen the website, section 3. So section 30 deals with secured creditor. Now, this is concerning the ninth topic number 9, where a statutory first charge is created on the property The municipal authority is entitled to enforce such charge independently in accordance with statutory mechanism provided therein. And the overriding effect under Section 238 of IBC will not get attracted. Now, this is a case, Cotton Casuals India Private Limited versus State of West Bengal, decided by Calcutta High Court. You can see the case in the website. Now, let me take you to the details are here as well. Now, let me take you to the PowerPoint presentation. Now, what I told you, what do we see? Where a statutory first charge is created on the property by municipal authority, and the municipal authority can enforce such charge independently in accordance with the statutory mechanism therein. Overriding effect of Section 238 will not apply. Now, this was decided by Calcutta High Court in this particular case, Cotton Casuals. This was, in this case, it was an insolvency bankruptcy case, Insolvency Bankruptcy Code case, in which the question of Section 238 came. So, like the first one, Section 3, subsection 4, in this, the High Court held that this particular charge was not created on the company. This was on the property. And the liquidator, while making the drawing up the terms and conditions of the auction, had mentioned everything, and it was a sale on as is whereas basis. And he had also mentioned that whatever documents were, and he had also requested bidders to do their own due diligence. Now, what the court said is that KMC, the charge was created by KMC, and KMC was at the liberty to approach the liquidator or to auction the property themselves. So, amount payable to KMC was out of the purview of Insolvency Bankruptcy Code, and the bidder had to pay for it, irrespective of whether this was pre-CIRP or pre-liquidation. It didn't matter. Whatever money was due to KMC was payable. And you'll remember this particular thing was also, if I'm not wrong, this particular thing was also, it came up in KC Ninan, I suppose. If we go to website, yes, Kolkata Municipal Corporation versus Ganesh Lalchand Jain. And I think I had discussed this in one of my podcasts also. So with this, we come to the close of the second case. We move on to the next one. Thank you. Our third case pertains to Section 7. Section 7 cases are repetitive. They come almost every day. But still then, this is something new, so I thought of discussing this with you. Let me share the screen with you. Yes. Now let us come down to topic number 13. The joint development agreement is a contract of reciprocal rights and obligations, and thus debt is not financial debt, and as such, Section 7 application is not maintainable. This type of case we have seen many. This particular case is Airwell JKM Infrastructure Private Limited versus Cadillac Infotech. You can see this case, peruse this case on the website. Now let me take you to the PowerPoint presentation. Now, as I said, joint development agreement is a contract of reciprocal rights and obligations, and thus it is not a financial debt, coming under subsection 8 of section 5 of Insolvency Bankruptcy Code. And thus Section 7 application is not maintainable. Now, in this particular case also, what happened, there was a MOU between the developer and the owner of the land, and Noida Authority was also there. There was 16,000 square meter area in Sector 135, Noida, was supposed to be developed. Thus, the nature of transaction between parties were essentially developed for development purposes. There was nothing of time value of money. So, and this was not a case of granting any loan or financial facility to the corporate debtor. So, under no circumstances, Section 7 was applicable. And thus, amount given to the corporate debtor was not of the nature of loan of financial institution, financial assistance, and thus Section 7 was not permissible. We have seen this case, but this would help you in recapitulating earlier cases also. So with this, we move on to the next case. The fourth case, which we are going to discuss, also pertains to Section 7, but it deals with something new. So let us take you over to the topic section of the website of Section 7. So if we look at, we have seen, if we look at 38, 38 says that adjudicating authority is not concerned with determination of exactness of claim. But 39 says what? The adjudicating authority is not entitled to examine the reason for commission of the financial default under Section 7 of the Code. So this is something absolutely new. If we come to the case, this is Vishal Arora versus Union Bank of India. So the headline says that the adjudicating authority is not entitled to examine the reason for commission of financial default under Section 7 of the Code when the requirement of debt and default are clearly established. The details of cases here. Now we have to remember here that NCLT is not a court, it's a tribunal, and the proceedings which we have are summary proceedings. So with this, let me take you over to the slide. Now, adjudicating authority is not entitled to examine the reason for commission of debt and default under Section 7 of the Code, when the requirement of debt and default are clearly established. Now, there was a tripartite thing. The developer or the builder had availed loan from Union Bank. He had given development rights to somebody, and there was problem between NHAI and the party. Now, this problem was going on. The debt was restructured number of times. It had become NPA. So the court said that the default is established. The debt and default is established. The fight is between NHAI and CD. It has got nothing to do, NCLT has got nothing to do with it. It is only supposed to see whether the debt and default has occurred and whether it is over the threshold limit of Section 4, which was there. So the debt was admissible. Since there was default, Union Bank of India moved to NCLT for initiation of Section 7 petition. And since debt and default were established, the Section 7 was admitted. So the fight which was going on between CD and NHAI and things, NCLT being a summary proceeding fora, was not supposed to enter into it. And that's the matter. Matter ended, the case was there. Case was admitted, it went to NCLAT, NCLAT upheld the views of the NCLT. So this is a new thing. So with this, we move on to the fifth case. Now, the next case we are going to deals with PUFE petition. And PUFE comes under Section 26, Regulation 35A, and also Section 43, 45, and then fraudulent is 66 and things like that, fraudulent transaction. is 66. Now let us move on to the website. Now we can see that application for avoidance petition. Section 26 deals with avoidance petition. Now, this particular topic is avoidance petition can be pursued after approval of resolution plan, and the SRA, if authorized by in the plan, will get automatically substituted. This was decided by NCLAT in the case of Raman Gupta versus NARCL. You can peruse the case in the excerpts from the case in on the website. But let me stop the screen share and take you to the slide. What NCLT, we know that we have dealt with this particular matter earlier also, and we have a very clear idea that PUFE petition, especially when there are elements of fraud. Fraud doesn't have any time. And PUFE petitions can be pursued even after the resolution plan is approved, or even after the dissolution, after the dissolution petition is approved under Section 54. So in this particular case, Raman Gupta versus NARCL, what happened was NARCL was substituted by ARP. The persons, against whom Section 66 were moved, they challenged. They said that how can this substitution take place? And NCLAT said that it is an automatic process. The substitution automatically, RP is no more there, his function, his role is over. And once the resolution plan is implemented, the resolution plan is passed, automatically the pursuing the PUFE petition would go out to SRA if such a thing is mentioned in the plan, or would be continued by the financial creditors. It depends on what is mentioned in the order or in the resolution plan. That's it. So with this is a direct case, and so I thought you'll be interested. So this case is featuring in this podcast. So with this, we move to the next case. Now we are coming to section 30. So let me take you to the website. Yes. So you can see IBC, Guide to IBC, the table of sections and regulations. So let us come to section 30. Yes. Topics. Let us go to topic 80. Now, before going to topic 80, I would like you to remember the glass trust case. So what did the Supreme Court mention in glass trust? Supreme Court mentioned that once a CIRP is admitted, it is no more limited between the applicant and the CD. This is a case in rem. Now, this particular topic deals with that. So what NCLAT here has said is merely because CIRP proceeding is a proceeding in rem, it still does not accommodate those who, by their conduct or otherwise, have been rendered irrelevant in the procedure. This is a case of Astral Agro Ventures versus Valakati Balasubramanian, decided recently by NCLAT. So merely because CIRP proceeding is a proceeding in rem, it still does not accommodate those who by their conduct or otherwise have been rendered irrelevant in the procedure. In this particular case, what happened was not an unsuccessful resolution applicant. A resolution applicant who did not submit a plan challenged the thing under Section 29A, stating that they were irregular, the procedure adopted were irregular, the SRA was barred under 29A. Now let me stop it and stop the screen share here. You can see the case on the website. Let me take you to the screen share. Now, as I gave you a brief background of the case, The mere fact, the NCLAT said that the mere fact that a PRA, an unsuccessful resolution applicant, establishes a relationship with CIRP procedurally, still may not be enough to grant them license to gatecrash into CIRP proceedings. To challenge a material irregularity which they may allege having occasion, they must have participated in that stage. So, in order to say that there was irregularity in approval of resolution plan, he must have submitted the resolution plan. If he had not submitted the resolution plan, he has no locus to disturb the resolution plan approval process. We see, as a matter of fact, in this particular case, the court came very heavily. The cases are prolonging, and because of this nonsense petitions being lodged by those having no locus. So court came heavily on this. They gave some recommendations also. So this is an interesting case. I would suggest that you should go through it on the website, and I think you'll like it. So this is a particular case of good interest. So thank you. We move on to the next case. Now we are coming to section 31. We have seen this topic earlier also. So let me take you to the website. So you can see Guide to IBC, the table of sections and regulations. We come to section 31. And this is also topic 80, like the earlier one. So what does topic 80 say? Concerted efforts and decisive actions are imperative to break the deadlock and ensure that expeditious implementation of the resolution plan. Now, we have seen multiple cases, as you can see. Already 4 cases you have seen. State Bank of India, Consortium of Murari Jain. Last we had Bulan Realtors Private Limited versus State of UP. Now, this is Mohan Reddy versus Bhumi Reddy Gari. Mohan Reddy, Bhumi Reddy Gari versus STCI Finance Limited. Now, this case is little peculiar. So, I would recommend that we don't have so much time, so you should go through the excerpts from the case on the website. But let me stop the screen share here and take you to the slide share. Now, this particular case is a little different. Why? Because in earlier cases, we had seen that NCLAT had opined that the monitoring committee or the FC, etc., should cooperate with the SRA to have the plan implemented, because it was SRA alone is not responsible. It requires a concerted effort from everybody. Now, this concerted effort is required from FC, XRP, the monitoring committee, and most importantly, who? The adjudicating authority itself. So in this particular case, what happened? ED had attached the properties of the seal. But one flat had remained out of it. The matter had moved up to Supreme Court. Supreme Court in Delhi, I think it went to Delhi High Court or Bengaluru High Court. Bengaluru High Court had allowed, had quashed the provisional attachment, but then ED moved to Supreme Court, and Supreme Court kept the provisional attachment. But then later, while checking, they found that the one flat, measuring about 3,500 square feet, was out of the list of attached properties given by ED. Now the SRA moved to NCLT and said that this property is out. So allow me to implement the resolution plan. The NCLT said, no, looking at though this is not there, prima facie it is not there, but looking at the mood of Supreme Court, let us take on. So NCLAT came heavily on NCLT and said that adjudicating authority has committed a manifest illegality in not ascertaining as to whether the aforesaid flat was in fact provisionally attached by ED or not. If this flat was not attached by ED, then SRE should have been allowed to implement the plan. I mean, and if it was allowed, so fine. The order of the Supreme Court would prevail. But just to pass on the buck it's not expected. So this case, though it pertains to the same topic, but touches a very, very clean niche. And that's the reason why I'm sharing this with you. So with this, we move on to the next case. The next case which we are going to deal with relates to Regulation 35, that is valuation, and also Section 31. So let me take you to Guide to IBC, and then from there we move on to the case. Yeah, we can see the table, Section 25, View Regulations. We come to Regulation 35, Fair Value and Liquidation Value. This deals with topic 16. There is nothing in law to suggest that if any land is not mentioned in the audited books of the corporate debtor, the resolution professional cannot treat it as a fixed asset of the corporate debtor and direct its valuation. This is a case between IFCI versus Raju Kesavan. The details are here. Now, in this particular case, what happened was, you'll see the case on the website. The company had availed loan from financial institution by mortgaging various properties. Some of it belonged to it, some of it belonged to third parties. And with respect to some properties, though the initial purchase value was there, but RP did not find the deed. So while valuing, it did not value the liquidation value. And with regard to assets of the third parties, the RP simply directed, though company was developing asset there, developing a housing complex there, it directed the valuer not to do any valuation there. Now, you will definitely remember in the case of Tea Garden, in which Ram Ratan Modi case, it said the development right is a property of the corporate debtor. But let me take you to the slide. Now, what the court said, that no liquidation value was given to it on the pretext that it never got capitalized in the books of accounts of the corporate debtor. And its sale deed was also not given to the resolution professional. But there was a development agreement. So this land was not included in the information memorandum also. So this non-inclusion of land in the information memorandum violated the basic requirement of information memorandum. For the purpose of IBC, the expression asset includes properties of every kind. And later, there was an enforcement directorate and seized the assets of the company and found many assets. So that part we are coming to it in section 31. So let me stop the slide share here, take you to section 31 as well. Let's see if we can cover that in the same video. Let's see topic number 34. The topic number 34, as you can see, that if new assets are discovered after approval of resolution plan, CIRP may have to be revived. So this was the case of IFCI Limited versus the same case in which, as I said, the ED unearthed multiple assets. And the SRA had mentioned in the plan that if subsequent to the resolution plan being approved, if other assets are found, then it would belong to him. The court held that no, sorry, you cannot make a blanket thing like that. That is wrong. So let us take you to the screen, to the slide share. So if new assets are discovered after approval of a resolution plan, CIRP may have to be revived. Admittedly, I mean, as I said, the thus crucial aspect were never placed before the Committee of Creditors, and it cannot be said that the Committee of Creditors' commercial wisdom would prevail because the Committee of Creditors did not even know about the existence of the assets. So the resolution plan which was approved, it cannot be said that it was approved through commercial wisdom of the Committee of Creditors. So the approval of resolution plan was cancelled and it was remitted back to NCLT. So with this, we move on to the next case. Case which we are going to deal with dates with section 60. This case is not pertaining to Insolvency Bankruptcy Code, but we often face situations in which we have to refer to other cases to which and draw inference. Yeah. In fact, in one of my cases, I'm facing a situation. In Pufe petition, NCLT has passed an order against the CD, the promoter of the CD, and imposed a heavy fine. So the promoter doesn't care for it because the FC, one of the FC has moved to Section 95 petition. Says, fine. You let them go take me to bankruptcy. Doesn't make any difference. I won't pay the money. So this is a matter something like that. So let me take you to the website. Section 16, topic 115. So where execution is sought against the assignee or receiver in insolvency, and the party has been adjudged to be insolvent, the executing court shall issue notice to the person against whom execution is sought. Now we know that any decree or any fine imposed is an excluded debt. So this was held in the case of Bharat Capital Shade through LR. It's a Supreme Court judgment, very recent judgment. So it said that where execution is sought against assignee or receiver in insolvency, and the party has been adjudged to be insolvent, the executing court shall issue notice to the person against whom execution is sought. The details you will find on the website. So let me stop the screen share and take you to the PowerPoint presentation. So where execution is sought against the assignee or receiver in insolvency and the party has been adjudged to be insolvent, the executing court shall issue notice to the person against whom the execution is sought. The notice will require him to show cause why decree should not be executed. The requirement of notice under Order 21, Rule 22.1 to the persons enumerated therein is not a mere procedural courtesy, but is a very foundation of jurisdiction, where execution is sought against the estate. So you attach the estate of the person, execute the duty against the estate of the person. And it provides, and when the person, I mean, the notice itself, the person has every right to raise objections. And the court is going to consider such objections and pass such order as it may think fit. So this is a very important matter. This essentially concerns situations like I told you. And it is important to have an idea about it as to how to deal with these matters. So with this, we come on to the next case. So section 95. We come to the last topic. The adjudicating authority, without citing reasons, cannot ask for disclosure of personal assets and statements of bank accounts of family members. This is a very recent case of Jayesh Vinodlal Walia versus Canara Bank, in which the NCLT had asked for personal details of personal assets of the personal guarantor, as well as bank statement of his family members, without citing any reasons thereof. You will find the case on the website. So let me take you to the slide share. Now we will remember that in Section 95 proceedings, what the adjudicating authority is supposed to do is, based on Section 99 report of the RP, he judges whether there is a bank guarantee, which has bank guarantee was given, and it has been demanded, and it is due. Now, if he's asking for whether pertaining to what are the assets of the guarantor is a matter which is to be seen under Section 99. And furthermore, it has got nothing to do with the family members as well. So if adjudicating authority is asking for disclosure of personal assets and statement of bank accounts of all family members, he has to cite reasons thereof. Because asking for a statement of bank accounts of family members is that it's out of the purview of Insolvency Bankruptcy Code. So this particular order was not sustained, and it was set aside by NCLAT. And this is an exceptional thing. You may come across things like this, but that is why this has been shared. So with this, we move on to the next case. Our next case is also pertaining to personal insolvency, and that is personal guarantor matter. And this relates to Section 100. So let me take you to the website. Yeah, we can see Section 100. This is topic 9, I suppose. Yes. Now, we know about debentures. Debentures can be NCD, that is non-convertible debenture, can be CCD, that is completely convertible debenture, which is not a debt at all. It's an equity as held by Supreme Court. And also OFCD, that is optionally fully convertible. So that means there is an element of debt, an element of equity. Now, in this particular case, it is exactly mentioned in that manner. The OFCD is a hybrid instrument, part equity and part debt, and hence the debt quantum must be determined. This is a very recent case of Chennai bench, Mr. B. Nirmal Kumar versus LIC Housing Finance Trustees Company Limited. You can see the case details on the website. Interesting case, no doubt. But let me take you to the slide share. What NCLAT said is funds raised by debenture deed were OFCDs, which were joint financial assistance extended to CD for 3 real estate projects. Now, OFCDs were due to mature in 3 years' time, and they were renewed through a supplemental agreement. Now, as for in the instant case, the financial investment, it was found that the IRR was 30.32%. So court herein raised his eyebrow and said that expected return of debt instrument is much less. 30.32% return you can expect when it pertains to equity. But in a debt instrument, you do not expect such kind of return. So it was necessary to determine what is the debt quantum and what is the equity quantum. However, court in its wisdom admitted the case under Section 100 and mentioned that RP should determine at the time of submission of repayment plan how much is debt and how much is equity. In my opinion, court could have turned it down also, but then I'm no one to challenge. I'm no one to comment on the wisdom of the court. But the fact is, in OFCD, it has to be determined how much is debt and how much is equity. So with this, we move on to the last case. The last case which we are going to deal with does not concern with Insolvency Bankruptcy Code, but deals with high C contract, and it's an arbitration matter. Why I have included is that because cross-border insolvency is very much in the radar of the policymakers, and it is better that we should have an idea about it. So that is the reason I have included this particular case, and you should have an idea, and that's the reason why this case is included. This I have related to Section 234 of Insolvency Bankruptcy Code. So with this, I take you over to the website. We take you over to 234. In a high C sales contract, jurisdiction of Indian courts cannot be manipulated. The mother contract will be referred to in determining the governing law. This is the case of Balaji Steel Trade versus Fludor Benin SA, arbitration matter of Supreme Court, very recent case. So it says that in a high C sales contract, jurisdiction of Indian courts cannot be manipulated. The mother contract will be referred to determine the governing law. The case details are here. It's a very interesting case. And I think we should go through it. Case details are given in short and on the website, and it will give you a good idea. Because, as I said, cross-border insolvency is very much in the radar of our policy makers. So let me take you to the slide share. The Supreme Court, Honorable Supreme Court, opined that the seat has a jurisdictional significance in arbitration law. It determines the court that exercises supervisory jurisdiction on the arbitrary proceedings. And how does one determine where is the seat? It is gathered from the agreement as a whole. So in this particular agreement, the principle of the mother contract indicated that the governing law or the place of arbitration to take place in Benin, under Benin law. So by the absence of cross-border reference or language of substitution makes it impossible to infer innovation under Section 62 of Indian Contract Act 1872. So it cannot be by mere making some additional documents and additional agreements, supplemental agreements and things, supplemental terms and all, you cannot possibly manipulate. And Supreme Court declined. It stated it doesn't have jurisdiction to handle this particular case. Delhi High Court, in fact, it turned down the order of Delhi High Court. Indian courts have no jurisdiction to appoint an arbitrator for a foreign-seated arbitration, irrespective of the nationality or domicile of the parties. So this, though it doesn't pertain to Insolvency Bankruptcy Code, but this is a very relevant matter which we should keep in our mind. With this, we come to the conclusion of our presentation. And the end part, the epilogue, is going to follow this particular after this.
Viewers, we have come to the end of our presentation. I hope you liked the topics as well as the cases which have been presented. They will impart good knowledge to you, good wisdom, and we look forward to seeing you again in the next week. Thank you.